We kick off this second hour of Court TV Live with some big breaking news. We were expecting the murder trial for defendant Sarah Grace Patrick to begin today, but the trial has just been continued. Patrick is the Georgia teen who's accused of murdering her mom and her stepfather. Jamie and Kristin Brock shot and killed inside their home back in February of 2024. The couple's 5-year-old daughter is the one who made the gruesome discovery of their bodies, and Sarah Grace is the one who placed the 911 call to report it. She cried at their funeral, even delivered the eulogy. Then 6 months later, she was arrested. She is 17 years old now. She was 16 at the time of the incident in question, and she's being tried as an adult. I want to bring in now Court TV legal correspondent Kelly Craft to give us more about why the continuance happened today. Good morning, Kelly.
Good morning to you, Julie. We have been monitoring this case, really looking forward to it taking place, getting off the ground. We had heard that opening statements would likely take place tomorrow. But we are now hearing, as Julie just mentioned to everyone, that this case has been continued. This happened just moments ago. Now, this morning, what was taking place inside that courtroom, defense counsel had indicated that they are ready to proceed in this case. The state is the one that is asking for the continuance, and this is all based on the neuropsychological evaluation of the defendant in this case, Sarah Grace Patrick. So her defense counsel had wanted to get an evaluation of her. So they had people go and they were visiting with her on several different occasions. The preliminary report of this was just sent back to counsel on December 31st. So it's not even a final copy, Julie, and that is exactly why the state is wanting this continuance. They are now saying that they need to get their own expert after just taking a look at the draft.
Sure. Yeah, and this is not unexpected, Kelly. I have to tell you, we were talking about it this morning, that this was a possibility because that evaluation happened back in August. Still no report, not saying it's the fault of the defense attorneys. This expert that they consulted with is the one responsible for generating it, but just a draft on New Year's Eve, fundamentally unfair to the other side. Kelly, I have video from the hearing just coming in. We're able to show this, so if you'll stand by, we'll talk about this afterward. Let's play the back and forth between the lawyers and the judge.
We're ready. All right, Ms. Patrick, just before you came in, we're calling through the trial calendar, okay? All right, on the trial calendar, your attorney has announced ready, and the state says they have a motion, so we brought you out so you can be present for that motion, okay? All right, if you have any questions along the way, that's what your attorney's there for. If you have questions that your attorney can't answer, she knows that she can reference those to me. So just make sure you speak with your attorney, okay?
Yes. Okay.
All right, Ms. Weeds, we good?
We are young.
All right, State.
Thank you, Judge. At calendar call on December the 16th, Ms. Williams and the state both indicated that the report regarding the psychological evaluation or the neuropsychological evaluation was not back yet. On December the 31st, we did receive a preliminary draft of the report from Ms. Williams, but as of right now, we still don't have the final copy of that draft. And after just reading the preliminary draft, the state does believe that we need to evaluate that to retain our own expert in that matter. So at this point, because of that, like I said, on December the 16th, how we might need to evaluate that for an expert report, the state is going to be asking for a continuance in this matter.
Your Honor, we are opposed to a continuance. We are asking that the court would let us go forward. I had indicated that we would get that report shortly after that court date. As soon as I got it, I did forward it over to the state. But we are ready to proceed despite, having the preliminary report. We anticipate that I would have the final draft of that report and have it over to the state by the end of the week, and I think we can go forward.
But Ms. Williams, you're not even in possession of the final report at this time, is that correct?
That's correct, Your Honor.
The state, your argument is that even on the preliminary report, for y'all to adequately present your case, you need time to have an expert look over their expert report, is that correct?
That's correct, Judge. When we go over the preliminary report, without getting into the preliminary report itself, there are some issues that the state does believe that we need to at least evaluate to get an expert report in that case to rebut their expert. And again, and I know Ms. Williams does it, but the state still doesn't have a final copy of that report, which, and today would be the start of her trial.
Before I go too far, I want to compliment both defense and state. Anybody who is in the legal system knows that I put a very rigorous schedule on each of you. To have a alleged double homicide case ready within 4 to 5 weeks is lightning pace. And y'all both, state and defense, have done a phenomenal job. Y'all have had conference calls with me regularly ever since that date. Y'all have kept the court well informed of where y'all are at, and what was needed, and what was going to happen. And y'all have done that even for today. We've had multiple conference calls before this hearing. We all kind of knew what was going to eventually transpire today, but that's because of y'all's diligent effort. And so, Ms. Williams, thank you. State, thank you. Ms. Williams, I do not believe that the delay in this report is a tactic or a fault of yours at all. I think that expert reports, from my own experience, they take time. And just the time frame that I laid down for this case did not give your expert enough time to get things done in a matter of time to give the state what they needed to do. While I know that you're saying you're ready, I also know that you need that full report, and you don't have it. I think that you're weighing that against saying that your client's in custody and you want to be ready to move forward for her best interest, but I also know that you want that full report as well. For you to get that full report a week from now or 2 weeks from now in the middle of trial, and the state to get that report for the first time at that point and then decide they need an expert, I do not think that would be fair and just for either side. And we've had that conversation candidly and honestly with each other during conference calls. So even though I'm very reluctant to give a continuance in this case, I do think that it would be appropriate. With that being said, I don't want this case to languish. I still hold by what I told Ms. Patrick at the beginning. I don't want her to sit where she doesn't need to sit. That's not where she's supposed to be. And only the facts of the case will let us see that every day. In order to get there, I got to try this case. So I have dates. I have a trial week that can handle this type of case in March. I have one that can handle this case in May, and I have one that can handle this in August. Now, you both know what's really there. Ms. Williams, you know the true ins and outs of your side and what's really needed. State, I think you're starting to see, based on this report, what you may actually need. Realistically, from each of you, when can y'all tell me we can be ready by this date and this case not have to be moved?
Judge, from the state's perspective, I think the best date would be that August date for everyone. That seems to be a date that will match up with what our needs are in terms of coverage for other courtrooms, as well as just the opportunity for our experts to prepare to combat any and all defenses as presented by Ms. Williams and the defense.
Ms. Williams?
Your Honor, I think that August would probably be the best to fit the court's need of not having to move it again. Realistically, I think that maybe if we said, March, we probably would be back here at in the same position to say, hey, maybe we need a little more time. So I don't often agree with the state, but I will say August would be the best bet if we're trying not to come back here and have the same announcement.
So I don't like setting cases just to set, which is why, in all candor, it'd be easy for me to sit here and go, let's place this on March, but know in the back of my mind, March is not going to be a realistic date. So with that being said, we go with August. State, you're saying August. Defense, you're saying August. Are we all under the understanding that the chances of this case being moved off that August date are slim to none?
Absolutely.
And that barring some true just legal issue that I have to honor for fairness and justice to prevail, outside of that, we are going to make this case go and move. Everybody can agree with that?
Yes, sir.
Yes, sir.
Ms. Williams, you've talked with your client about this ahead of time. I know that. She is still in custody. I understand that today would have been a better day. Is your client also comfortable with that August date?
I don't know if comfortable is a good word, but I've advised her of where we are and what moving into August would mean. And strategically, I think, and practically, she trusts me and my advice, and so I think we are in a position where we'll be okay with August.
Okay. All right. Based on what's been presented for me today, I will place this on, I believe it's August 3rd. We'll place this on August 3rd. And with the understanding that if I'm going to bypass 2 trial weeks in order to get there, I'm bypassing 2 days that I could set it on, right? But by doing that, I'm giving defense and state all the time that you could possibly need to have this case ready. And August 3rd needs to be our day. We need to come in August 3rd, ready to pick a jury. All right? Where everyone's on the same page.
Yes, sir.
Okay. Again, I do want to stress how grateful I am to defense and state on how well y'all attacked this case. The general public, I don't believe they fully grasp the difficulty of preparing a case like this. While we did set this at a very ambitious date, August still has Ms. Patrick getting tried within a year of her indictment. In other words, we will not reach a year of her indictment when her case comes to trial. Again, for a case like this, if you look across the state and the country, that is very fast, even in August, Ms. Patrick. And I believe your attorneys probably explained that to you to some degree. But it does need to be August. So August 3rd.
Thank you, Judge.
Thank you.
And with that, the judge grants the state's motion for a continuance, all because they haven't gotten the report from the defense expert. As a matter of fact, the defense hasn't even gotten the finished report. They only have a draft of this neuropsychologist report, the evaluation done back in August, the draft given to the defense on the 31st. So we're talking not even a week ago. And as the judge noted, it would be fundamentally unfair to force the state to go into this trial, receive the report mid-trial, then have to find an expert, have another expert assess the case, weigh in. It may be too little too late. So they have set this case out in August as a new trial date. A lot to unpack here. Court TV legal correspondent Kelly Craft is still with us here in the studio. Let's talk about that issue of the fundamental unfairness. I want to pick your brain. You've done appellate work. And so thinking about this, as we were heading into the case, I remember thinking, these prosecutors are probably going to have a problem with this, even though this defendant's asserting her right to a speedy trial, which she has. But when you get in a pinch like this where the state isn't causing any delays here, there can't be an unfair surprise, can there be, Kelly?
No, and if this were to proceed, the judge made the right decision, Julie, because if they were to proceed without having that final report, which is a powerful piece of information for both sides, and then not allowing the state to bring in their own experts to analyze. Attorneys aren't experts in these kinds of evaluations. They need someone to come in, take a look at the report, and as we heard the attorney say, the prosecutor there say, we want to find someone, our expert, to rebut a lot of the findings that we even are seeing now in this preliminary report. If the judge would have allowed them to proceed, as defense counsel was very clear they wanted to proceed, this would just be ripe for an appeal.
It really would be, Kelly. Yes. In defense counsel, let's look at things from their perspective. As you noted, they're saying, we're ready to go, Judge. We're not agreeing to this continuance. We're ready to go. We're ready to proceed. Our client wants a speedy trial. They're in a tough spot, too, aren't they?
They are, and they do not want her sitting behind bars any longer than she has to. And the judge made that clear when she was denied bond. We saw Sarah Grace Patrick really break down when that bond was denied. So she's behind bars, and the judge has said, I don't want any defendant sitting behind bars longer than they have to. We want a speedy trial. We want to go to trial as fast as possible. And we heard him evaluating different dates there. It was as if he was a little bit reluctant to go out to August, but he said he doesn't just want to arbitrarily set a date. August gives everyone, it should, enough time to have this final report, have the analysis complete, find the experts from the state to rebut any of the findings that they feel need to be rebutted, and then go forward in August. I mean, that's several months from now.
Right, Kelly. That's a long way out. That was one thing that surprised me a little bit, and then it got me thinking. I wonder if there have been discussions, and as you know, we're not privy to any plea discussions. We don't know if there have been any offers. You know, sometimes we find out, as you know, after the fact, after a trial concludes. I wonder if this is purposeful, to see what the state's expert says, report back the findings, and then give the state some time to think about whether or not they want to make an offer, if they haven't already, to this young lady.
And Julie, it could be, because sometimes we do see continuances based on the fact that there might be plea negotiations going on back and forth. In this case, that's very possible. As we heard the judge mention, this is a double homicide case. And so when you prepare for a double homicide case, that takes a great amount of time. And the judge commended the attorneys for being ready to go. And defense counsel, they're saying that they are ready to proceed. But you never know what's happening behind closed doors. Could there be some sort of negotiation going on? It's hard to say.
It is, Kelly. You know, and these attorneys, as the judge noted, as you pointed out, did a fine job getting ready in such a short amount of time. I can't emphasize that enough. I know you know, because you've been a prosecutor like I've been. It takes a long time to prepare for a trial, especially one like this, a double homicide trial. So that's no easy feat. I want to bring in our law enforcement analyst guest, Sunny Slaughter, who's standing by. She also does litigation consulting work. So Sunny, let's talk a bit about that. To just prepare for a homicide case takes quite a bit of time. And then you throw in the mental health factor that may be at play here. Your thoughts on the judge's decision giving both sides more time?
Good morning, Julie. Good morning, Kelly. Happy New Year to everyone. So I think this was a good decision. And as somebody who's actually about to step back into the expert witness realm, people don't realize how much it takes. You have to get all of the information and then you have to review everything. And in my case, I'm like, you know, going over all of the details, listening to recordings. So whatever this expert witness had to deal with, whether they got things fast enough, whether they were able to get all of their information. Clearly, that was not the case. I think the judge made the right decision because this would have harmed not only the state's ability to respond, but really it would have been harmful for the defendant, because the defendant has the right to have all of the information available to present in court and to be able to respond, just like the state has the right to have all of the information available and the right to respond. I think this would have caused a delay in the trial because the state cannot answer what they don't know, and they need their own expert witness. So that expert witness now has to go through everything once they get the final report. And apparently the draft report is concerning for them. And one of the things that I really want to say is, what about if this report indicates that maybe this case should not be where it is and it should go to juvenile court? That's a possibility. So we're not sure, but I think the judge made the right decision.
Sunny, great points. And I really like the point you made about how you can look at this like glass half full, glass half empty. Kelly and I were talking about how she stays in jail, right? That's the downside if you're this defense team. Okay, we're not at the point of trial. She's got to stay behind bars. But the bright side, as you pointed out, is she's going to know what's coming from the prosecution. She's going to know who the next expert is, what their findings are. It gives their defense team an opportunity, as you noted, to refute it. So this actually is a good thing for the fairness that she's entitled to. Kelly, your thoughts on that?
No, absolutely. These are very, very detailed reports, and you need experts to take a look at them. And for the state to have to come in and proceed to trial really blindly, they would have an idea from the prelim, but to really proceed and come up with strategies, what's going to be in this report is going to dictate a lot of the prosecutorial strategy in this case. So them having the final report is imperative.
I couldn't agree more. Sunny, you touched on whether this case belongs in adult court or in juvenile court. Tell us more, your thoughts, please.
So based on the report, which is neuropsychology report, we don't know what that says and whether or not she had presence of mind, allegedly, if she is the shooter, to know whether not just about intent, but whether she was had presence of mind to understand if she did this, what the ramifications would be. And that is a really critical piece because she was 16 years old at the time, only 17 years old now. And is this a case, even though the prosecution says yes, that should be in adult court, or is this a case that should be in juvenile court based on what the findings are, not only from the defense expert, but from the state's witness? And that could be some of the plea negotiations that then take place between now and August between the defense team and the prosecution team. It might be not necessarily overcharged, but in the wrong jurisdictional court for handling this type of offense.
Yeah, Sunny, thanks for making that point. I am very curious to see if we see a resolution before the August trial date. I just have that feeling. I mentioned this morning in my opening statement how I keep thinking about that 5-year-old baby sister who had to make this gruesome discovery, who she could potentially become a witness. She's 6 years old now because of the finding, maybe not hearing an intruder, if that's the case. So to put her through another trial, if Sarah Grace Patrick did this, the state of Georgia says she did, you would think it would be especially cruel to put her sister through that. However, she's got the right to have a trial to make the state prove everything. Kelly, tell us what exactly the judge said in terms of any docket check-ins, or is the only date we know of that August 3rd date coming up?
You know, Julie, when I was listening to it, there may have been some docket check-ins, and I'm sure there always is. There's the case management. You have to come usually before, several times before the trial ends up taking place. And then usually, at least when we practiced in Illinois, we'd always have a Friday meeting as well, just to make sure everything's ready to go for Monday for trial. Right now, the date that I heard was August 3rd. John, our producer, and there may have heard some other dates that were following up, but when I ran into the studio, I heard August 3rd, just for the trial, Julie.
Right.
But certainly, of course, before anyone proceeds to trial, there are going to be some case management updates scheduled for court.
Yeah, definitely. Kelly, our experience certainly tells us that. So when they do reconvene in the courtroom, we'll get our cameras there and we'll film whatever happens. And in the meantime, if we hear of any pleas or any changes to the status quo, of course, you'll hear about it right here on Court TV Live. Kelly Craft, Sunny Slaughter, thank you.